30. Sound.
Good to go. Okay, so just the draft minutes then. So can I refer members to the draft minutes of the proceedings, and they're at pages 3, 6, 7 of the meeting pack. Are members content that the draft minutes of the meeting 21st of November 2024 are a true reflection of the proceedings? Content? Okay, and I'll sign them when I'm next in part of the buildings. Matters arising? No matters arising. Okay, so then we're now moving on to Regulation EU 2024-2847, and this is on horizontal cybersecurity requirements for products with digital elements. And we're going to have departmental oral evidence. So just to let everybody know, Hansard will be recorded. We'll be recording this evidence session. So the relevant papers are at page 60 to 125 of the meeting pack. And just again to remind members that the only articles 66 and 68 of the regulation qualify as amending replacing legislation. So these are the articles under consideration for us today. The Department for Infrastructure have provided an assessment of impact, which can be found at pages 118 to 120. This relates only to the amendment of regulation EU 168/2013, and that's dealing with vehicle type approval provided for in Article 68 of the Published Replacement Act. So DFI have also been advised that the officials of the British Government Department of Science, Innovation and Technology are preparing a response to this regulation, and the DFI officials are in attempts today to give oral evidence. Department of the Economy has stated that Article 66 inserts the Cyber Resilience Act into the scope of an existing market surveillance framework. Article 68 regarding vehicle type approval is the only other part of the Cyber Resilience Act that will apply here, and infers that market surveillance requirements will be limited to that element. And likewise, the Department of Agriculture, Environment and Rural Affairs and the Department of Finance both also hold interest in market surveillance, but both departments also concluded that the relevant articles only pertain to cyber security in vehicles. So those departments have therefore not provided an assessment of impact. And just to remind everybody, we will make a decision after we hear all the relevant evidence. So can I welcome Adrian Borland, Head of Vehicle Policy Branch from the Department of Infrastructure, and Paddy Kearns, Vehicle Policy Branch from the Department of Infrastructure as well. And just welcome both of you to the committee meeting, and I'm going to hand over to yourselves then for the provision of evidence.
Thank you, Chair. This will probably be familiar to you from the stuff we've already sent, but just to run through it. Regulation EU 2024-2847 aims to strengthen cybersecurity by laying down a uniform legal framework for essential cybersecurity requirements for a range of products that have digital elements. However, only Article 66 and 68 of Regulation 2024-2847 are relevant to DFI and qualify as the amending legislation being notified to the committee. The amendment made by Article 68 is to Regulation EU 168/2013 of the European Parliament and of the Council of 15 January 2013 on the approval and market surveillance of 2- or 3-wheel vehicles and quadricycles. That regulation is listed in Annex 2 of the Protocol under Heading 9, Motor Vehicles, including agriculture and forestry tractors. The amendment itself is the insertion of the entry, open quote, protection of vehicles against cyber attacks, close quote, into Table C of Annex 2 to Regulation 168/2013. Annex 2 itself provides an exhaustive list of requirements for the purposes of EU vehicle type approval, which must be complied with under Article 18 of that regulation. Table C of Annex 2 provides a specific list of vehicle construction and general type approval requirements. The effect of the amendment is therefore to ensure that in scope vehicles and systems, components and separate technical units intended for such vehicles must be protected against cyber attacks. The technical requirements that will apply in practice have not yet been stipulated and will be established in due course through a future amendment of Regulation 168/2013. Article 66 of Regulation EU 2024-2847 has an association to Article 68 amendment, since it's a typical amendment to the Market Surveillance Framework, Regulation 219-1020, which is done when a new EU regulation is made. The amendment adds Regulation 2024-2847 to the list in Annex 1 of Union harmonisation legislation, to which the Market Surveillance Framework applies. This is an administrative amendment to update the legislation, does not have any practical effect on the type approval regime itself. It's about establishing the framework for market surveillance from manufacturers and national authorities and the powers of investigation and enforcement. The committee will be aware that type approval is a reserved matter, and as such we have sought initial assessment of impact from Department for Transport. DFT have advised that there is no expected adverse impact from the amendment of Regulation EU 168/2013, since the type approval requirements for in-scope vehicles in GB and NI are intentionally aligned and no divergence will take place. It does not therefore appear likely that the application of the Replacement EU Act in terms of type approval of in-scope vehicles would have a significant impact specific to everyday life of communities in Northern Ireland in a way that is liable to persist. It is designed to have a positive impact in terms of cyber security. Not implementing the amendment would in fact have a detrimental effect, as Northern Ireland would potentially not benefit from the improved cybersecurity of products with digital elements used in the production of in-scope vehicles. It would also mean divergence from GB type approval schemes, which will be implementing the amendment. The Department for Science, Innovation and Technology, who are the GB lead department on Regulation 2024-2847, are currently working on a revised explanatory memorandum, and now that the regulation has been adopted, with the more recent conclusion of the amendment of Regulation 168/2013, DFT are providing input to that revision. However, the revised explanatory memorandum has not yet been completed and was not available for today's meeting of the committee. Happy to take any questions the committee may have, Chair.
Okay, thank you. That sounded pretty straightforward in terms of what we have to do. I mean, do you envisage anything different in the revised EM?
No, they don't envisage anything different at all.
Fair enough. Okay, thank you. Steve?
Yeah, just quickly. Thanks very much, Dean. Thanks very much, Steve, for the evidence. Obviously, we've got a significant cybersecurity sector in Northern Ireland, and it relies particularly on the fact that it's part of a UK system, and it's also with a digital sort of improvements and digital security system within that. Mm-hmm. What analysis has been done of any changes this is likely to make to the access that our cybersecurity industry in Northern Ireland will have to the rest of the UK, and obviously to the other elements of it that are quite important?
None in relation to the vehicles that are in scope that I'm aware of.
It's not just vehicles, this is also to do with our industry. It's not just, this is cybersecurity in the round. If you read the preliminary, it says, if you look at the draft legal text from the European Commission, it talks about cybersecurity products, digital elements, cybersecurity industry, digital industry. It talks about a wide area. It's not just vehicles.
No, but well, vehicles is DFI's interest.
I get that, but our job as a committee is to look at the impact, and we don't have other departments in front of us.
Yeah. Well, as I understand it, the generality of the regulation does not apply. It's not quoted in the protocol. Doesn't apply to Northern Ireland, and we're therefore subject to UK legislation on that. That's about as far as I could go.
Okay, thanks.
Okay, thank you. I mean, it is important to remember, Steve, you're right, there's a wider piece of legislation, but for this committee, it's really only Articles 66 and 68 that we have any impact on. They're the only things that come under the Windsor framework. So if anybody has no other questions, I just want to thank Paddy and Adrian for coming before us and presenting. So gentlemen, thank you very much.
Thank you.
Okay, so under paragraph 8.1, members of Schedule 6B of the 1998 Act, the committee must decide today whether or not to hold an inquiry into the published replacement EU Act that has been notified. So should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So having had regard to the legal advice on whether it appears likely that the replacement EU Act significantly differs from the content or scope of the EU instruments which it amends or replaces, and the departmental assessment on whether it appears likely that the Replacement Act would have a significant impact specific to everyday life of communities here in a way liable to persist. Can I ask, do members wish to hold an inquiry into Regulation EU 2024-2847, the Cyber Resilience Act?
Yes, I propose we conduct an inquiry because we haven't had the details yet on the EFM.
Okay, and is there an alternative viewpoint? Yep, Owen.
On this one, Chair, yes, there is, because I think based on the evidence that we've had this morning, it's clear that it doesn't significantly differ, and for the articles that would apply under the Windsor framework, it would not have significant impact. And the department, I think, was really explicit in their evidence that was their view. So I would not be in support of holding an inquiry on this particular item.
Okay, so Steve made his proposal first, so we'll just take a vote on that. So can I ask the clerk just to be ready to take a vote? So those in favour of the proposal to hold an inquiry, can they raise their hand?
Okay.
Okay, and those against?
Okay. Okay, the proposal to hold an inquiry into EU 2024-2847, cybersecurity. Ayes, David Brooks, Jonathan Buckley, Joanne Bunting, Steve Aiken. Noes, Philip McGuigan, Declan Kearney, Emma Sheeran, Owen Tennyson. The proposal therefore falls.
Okay. Thank you. So just to advise members that the committee's decision in relation to the Act will be published on its webpage. So moving on to the next item of business, which is Directive EU 2024-2853 on liability for defective products and departmental oral evidence. So again, just to remind everybody, this item will be recorded by Hansard. The relevant papers are at page 126 of the meeting pack, and I think a hard copy as well. Remind members the committee will need to take a decision on whether to hold an inquiry or not following the evidence session. So can I welcome Dennis Cunningham, Head of Consumer Affairs Branch from the Department of Economy, and Colin Jack, Head of Business and Employment Regulation Division from the Department of Economy, and ask them if they're in the room to step forward.
If I just advise, they're just about to come into the room now, so if we could just hold for...
Morning.
Hello, Dennis or Colin.
Okay, can I just welcome Dennis and Colin?
Sorry, Chair, I need to make a declaration of interest. I actually know one of the witnesses fairly well. Talking about our early morning activities, that's part and parcel of it, and also working through the church, so I need to make that declaration of interest. It's okay, Colin, I will refrain from asking Colin any questions.
All right. Okay, thank you. So just can I welcome Dennis and Colin to the meeting, and I'm just going to hand over to yourselves to present evidence on the EU regulation.
Okay, so the Product Liability Directive was adopted by the EU on the 23rd of October. It's been in development for the last couple of years. It comes into force on the 9th of December 2026, and it replaces a previous Product Liability Directive which was passed in 1985 and transposed into legislation here by the Consumer Protection Northern Ireland Order 1987. So it's really just modernising the regime in terms of liability of manufacturers and distributors of products that are unsafe or defective, so that consumers who are injured or badly affected by defective products are entitled to some form of compensation. Really, it reflects that the world has changed since then. I mean, in 1987, my exposure to the digital age sort of consisted of having a Sinclair ZX Spectrum, I think. So this is trying to take account of the fact that the internet has developed, software is important, we have smart products, moving towards having autonomous cars and so on, and the ways in which people can be adversely affected by defective products are changing. The legislation here, it's a mixture of devolved and reserved matters. DBT generally takes the lead because consumer issues are complex, and they have consulted on product liability as part of their product safety review, which they launched in August 23. And they raised the issue of the need to update product liability legislation in that consultation, and we're aware that the responses that they have received back are in favour of updating the legislation. So while we are not yet aware of the final decision of the UK government in terms of what they intend to do about this legislation or this directive in England, Scotland and Wales, we know it will apply here, but they've certainly been reviewing the relevant policy area, which would point to a likelihood that they will, if not fully, largely replicate this directive in GB. So that's where it appears to be heading at the moment. We understand they're working on an updated explanatory memorandum. I think the committee has a previous explanatory memorandum that was produced in 2022.
I think just to add to Colin, I mean, from a consumer protection perspective, it's good news that they are, like other pieces of consumer protection legislation that we've been dealing with recently, the Digital Markets and Competition and Consumer Act, there's a recognised need across Europe and, I suppose, worldwide to bring them in line with modern technologies, software, that online capability. Legislation consumer protection hasn't really addressed that. There's been gaps. So this directive is recognised, it's the attempt to fill that gap, which can only be a good news story for people who unfortunately suffer an injury of that in Northern Ireland, should be able to get some kind of recourse and liability compensation.
Okay, thank you. And just in terms of the point about British government updating the memorandum, is there any indication of when that updated EM is likely to be completed?
I don't have an absolute answer to that, but I believe I heard discussion about it should be within the next month, certainly. Early December was the time frame I heard.
Okay, and secondly, in terms of businesses or groups or organisations here in the north, is there they will have consulted with them? I mean, are there any impact or any people raising any issues with yourselves in relation to this potential legislation?
We're not aware of any, but I mean, we would need to probably do more research on that to be absolutely sure. But I mean, these are complex areas, and it's very difficult for any individual country to develop its legislation on this type of issue on its own. I mean, the markets in products are global, and particularly the type of products that this directive has been updated to take account of tend to be developed and marketed globally. So the issues that arise for consumers and businesses everywhere on this issue are largely the same.
Okay, and so you indicated that it's on the whole a positive piece of legislation, and that you expect that the British government to, if not fully aligned, to introduce legislation along a similar vein.
Yeah, I mean, that would be our expectation. I mean, this is an update of the directive which enhances consumer protection. It increases the level of compensation, I believe, that consumers can be entitled to if they are adversely affected by a defective product. It is, it's a positive piece of legislation.
Okay, thank you. David?
Thank you very much, Chair. I guess it's just to follow up the comments about it being a positive piece of legislation in terms of consumer protection, and that idea. I think you earlier in the presentation talked about the balance to be struck there, and I think it's just from our position as a rules committee is about trying to make sure that balance is right for Northern Ireland. And I mean, an example would be you can anything the EU does around regulations like this, there will always be an argument, I presume, that this is a positive thing, this is a good thing, there's good reason why we're doing this. We have to look at it from a Northern Ireland perspective. You could argue that raising the minimum wage is a good thing, but businesses might say that it will have a negative impact on them. And I guess I draw that comparison because I think this is similar here. Consumer protection is good, but we as a committee, I think, need to fuller understand what impacts, if any, that it may have on our businesses. And would you accept that there is a risk that in raising consumer protections in the way that you have here, that we do need to understand whether that will lead to increased costs for those who operate here, who sell into here, perhaps from GB and so on. So that risk of divergence and so on may have an impact on who is willing to continue to supply their products into Northern Ireland, or if they continue to do that in order to cover for the liability, they may have to raise costs in that sense.
Yeah, it's a very valid concern, and I think all I suppose we could respond in terms of that is in the discussions that we've had with DBC officials, they seem to indicate that they don't see that this is likely at all to have any detrimental impact on what actually becomes available on the shelves in Northern Ireland. I suppose, put into context, if you look at, I suppose you quite rightly refer to other areas of legislation where you could say the same thing. I think we're fortunate that in consumer protection legislation, the application of it and the protection for consumers and indeed for businesses to ensure fair competition actually predates EU. It's been going on to the late 1800s. So there's always been, we're fortunate that in the consumer protection field, there's always been a pragmatic approach by businesses and by governments so that businesses can operate smoothly wherever they are. Yeah. So I'd take some comfort that history would suggest that there will be a consistent approach when it comes to consumer protection matters. And
I agree largely, but just in Business Committee we can't take that on trust and can't take that on the idea that eventually they're likely to align in future. We have to have our eyes open because this is essentially the only lever we have open to us, and it is at this stage just a case of having an inquiry to make sure that all of those stakeholders who may be affected have the opportunity to at least feed into our work. So, and that's a decision we'll take here today. So appreciate your feedback.
I mean, I do think this is the type of issue where, from a business perspective, the fewer different regulatory regimes they have to comply with, the better. And I think, the consultation that was undertaken by DBT last year,
it's divergence that will cause the issue rather than
yes. And I think it appears the balance of the responses has been in favour of moving broadly in line with the EU on this.
I don't disagree
for
with
GB
that.
as well as here. So
I think it's true that the real risk to businesses is those businesses, whether located in Northern Ireland or online, if they produce defective products, that's the real risk that they face and a cost that they face. But consumers have to be protected and have to have the rights to get some kind of redress.
Thank you.
Yeah. Jonathan?
Can you hear me, Chair?
Yeah.
Thank you very much. Just obviously we've heard a lot about in recent times that general product safety regulation and the concerns that it might have for businesses supplying into Northern Ireland. Is it likely that this will significantly overlap?
As Colin alluded to in the August 23 review consultation, it was for exactly that reason that they identified at that time the need to marry the liability legislation in the same manner.
Okay, and it is disappointing that we don't have an updated UK explanatory memorandum at this stage to make a clear decision. Thank you.
Okay, and just a final point from myself, because David mentioned the issue of divergence, and I know it's different, but in EM that we have provided, both the Scottish and Welsh administrations have come back and said they have no issue with the legislation. That still stands as the case today.
Yeah, we believe that position remains the same, yeah.
Okay.
But certainly, I mean, I think, you know, it would be much easier for the committee today to have the updated EM available to it from DBT.
I suppose all we could respond to that would be in the consultation that they did on the product safety review, where they asked people's views about liability. In those responses, we do know that it mirrored the concerns that the directive actually suggests about needing to redefine product to include a wider definition and to allow consumers to have reduce the number of barriers to their redress. So I mean that's come out in that consultation, but Colin's correct until we see the formal position from the UK government in terms of revise the explanatory memorandum. Then that's the only position we can take as officials.
Okay, thank you. So nobody else has indicated that they want to ask a question. So can I just thank Dennis and Colin for coming and presenting that evidence to us today. Gentlemen, thank you very much.
Thank you.
Thank you.
See you tonight.
Okay, members. So again, Schedule 6B to the 1998 Act, the committee must decide today whether or not to hold an inquiry into the published replacement EU Act that has been notified. So should the committee fail to decide, the failure will be treated as a decision not to hold an inquiry. So having regard to that, having regard to the legal advice on whether it appears likely the replacement EU Act significantly differs in whole and apart from the content or scope of the EU instruments which it amends or replaces, and the departmental assessments on whether it appears likely that the replacement act would have a significant impact specific to everyday life of communities here in a way that is liable to persist, can I ask members, do you wish to hold an inquiry into Directive EU 2024-2853 on liability for defective products? Owen.
Thank you, Chair. And look, notwithstanding, I think the positive soundings that we had from the department in respect of enhanced consumer protection and the conversations that they've been having with DBT, I'm conscious that we only have an explanatory memorandum from 2022 which says that the cost to Northern Ireland at this stage has not been assessed, and we haven't yet been furnished with any additional information in that regard. And I think we do need to have a better understanding of costs before we can really assess whether this will have a positive or negative impact in Northern Ireland. So on that basis, and Steve might fall off his chair with this one, but I would be proposing that we would hold an inquiry in the hope that we would receive the updated explanatory memorandum in the course of that inquiry to satisfy us of those concerns.
Okay, Declan?
Yeah, based on Colin's evidence that the updated EM could be available within a month or perhaps slightly after that, I think in these circumstances it is prudent and it is proportionate to initiate an inquiry. Then we'll have that additional evidence and we'll be in a position to assess a more informed departmental perspective, balanced off, Philip, against the legal advice that we've received. So I support that suggestion that we should proceed.
Okay, any alternative views? Okay, so that's fair enough then. We're going to have an inquiry. Can I just maybe suggest through the clerk, because I mean obviously we have a break, and so even getting an EM in 4 to 5 weeks might actually will be outside that time frame, so that maybe that we write and just alert people to the fact that we have an inquiry and express urgency with regard to the updated explanatory memorandum.
If I could just suggest that the correspondence issues, but it maybe addresses the more general issue of not receiving explanatory memoranda at a time when a decision on an inquiry is being made, just in general terms.
Absolutely. Absolutely. No, if everybody's agreed, then that's the way we'll proceed. Okay, so just to remind member about the inquiry timeline, so that's set out at page 225 of the meeting pack. So we need to agree the inquiry timeline, and that includes scheduling an oral evidence session with departmental officials on the 5th of December, and then obviously agreeing our final report on the 19th of December. Also, can I seek agreement for views on the Act via Citizen Space Survey from key representatives of businesses and civil society identified by RAISE at page 226 of the meeting pack with a closing date of 8th of December. And advise members that citizens-based survey will be promoted on social media platforms and anybody will be able to respond. So is everybody happy with those suggestions?
Content.
Okay, thank you. And then aligned with agreed processes, views on the EU Act and its impact on communities here, and details of the position in England, Scotland, and Wales will be requested. So we've already outlined that, so that's fair enough. Okay, moving then on to the next item, which is Regulation EU 2024-2865. This is on classification, labelling and packaging of substances and mixtures, and we're going to have departmental oral evidence. Can I inform members that this item again is going to be recorded by Hansard? So the relevant papers for this item are pages 230 to 366 of the meeting pack and pages 3 to 34 of the table pack. Can I just inform everybody that assessments of impact have been received from both the Department for the Economy and the Department of Justice? And also the committee launched a public consultation on the draft agreed text for this via Citizen Space, which closed on the 12th of November 2024. The committee received one response from Fuels UK, which can be found at page 301 of the meeting pack. And attached to that response is an email from Fuels UK providing details of other stakeholders the organisation believes are relevant to, and to whom it forwarded a copy of the survey, but no responses were received. So they state that it is assessing the impacts of the amendment of the CLP regulation and highlights a possible consequence. So can I remind members that after hearing this evidence, we'll need to make a decision on whether to hold an inquiry. So can I welcome once again Mark McGregor, Principal Legislation, Goods, Regulation and Chemicals Branch for the DFE, Gareth Lyons, Deputy Principal, Legislation, Goods, Regulation and Chemicals Branch, DFE, Jennifer Stewart, Firearms and Explosive Branch, Department of Economy, and Aaron McKendry, Principal Scientific Officer, Department of Health. So over to yourselves, if you just want to give us the evidence.
Yes.
And present it. Thank you.
Thank you, Chair. Clearly, we were here a few weeks ago when we gave quite a substantive update on the CLP revision. I'm proposing just to give a briefer introduction today and some update to allow time for your questions at the end. So I'll just proceed with the brief overview of CLP. So that's Classification and Labelling and Packaging Regulation, which we'll refer to as CLP throughout. It sets uniform requirements for suppliers to classify, label and package hazardous chemicals appropriately before placing them on the market, and its purpose is to ensure a high level of protection of health and the environment and the free movement of substances and mixtures within the EU market. In 2022, the European Commission determined that CLP required an update to take account of scientific and technological progress and market developments such as online marketplaces. The key amendments in the CLP revision, which you're considering, the amended CLP regulation was published on the 20th of November, with amendments applying from the 1st of July 2026. Changes from 2026 include the requirement for a supplier to be established in the EU or Northern Ireland to be responsible for ensuring that substances or mixtures meet CLP requirements, new requirements for selling chemicals in refillable containers, labelling exemptions for chemicals sold in bulk or in small packaging, and new allowances for the use of digital labels or fold-out labels, new rules for distance or online sales requiring advertisements to clearly display hazard information, typically printed on a physical label, and requirements to update labels within 6 months where a new or more severe hazard classification is applied to a substance or mixture. There will be further amendments applied from the 1st of January 2027, which relate to new label formatting rules are being introduced, including minimum font sizes, line spacing, and requirements for all warning text to be printed in black on a white background. The requirement to submit relevant information to poison centres for emergency health response will now apply to distributors who relabel or rebrand substances. I'll briefly cover the initial assessment of impact. For much of this, we rely on our colleagues in the Health and Safety Executive of Great Britain, who provide scientific and technical advice to the Department. The Health and Safety Executive have highlighted a number of areas where the amendments to CLP may lead to additional costs for businesses trading in Northern Ireland. These include the need to redesign labels and relabel products,
updating advertisements and product listings in online marketplaces, training and implementation of risk management measures to comply with new rules at refill stations, and the requirement for certain distributors to submit emergency health response information to poison centres. They also noted trade between Great Britain and Northern Ireland may be impacted due to the requirement for businesses in the rest of the UK to comply with the amended CLP regulations to supply the Northern Irish market. The scale of this impact will depend on whether these businesses also supply the EU market and if equivalent amendments are made to the CLP regime in Great Britain. Costs may be mitigated if businesses can align relabelling with scheduled rebranding or marketing activities through new derogations for chemicals sold in bulk or in small packaging, or the use of digital or fold-out labelling. The benefits of the amended regulations stem mainly from the protection of human health and the environment. There's an ongoing assessment of impact where HSE have held discussions with UK-wide representatives on the possible impacts of the amended CLP regulation on Northern Irish trade. HSE are continuing to finalise a note of this meeting and have invited industry to provide further feedback before Christmas. Early feedback is the revised CLP regulation poses no cliff edge risk, but businesses will incur longer term compliance costs. And a full report on that survey will be provided to DFE early next year. HSE have also drafted a revised explanatory memorandum which will set out the UK government position on the updated EU CLP. That EM is currently awaiting clearance from relevant ministers in the UK government and will be provided in due course. Data collected by HSE from September's CLP consultation requires further validation work before being shared publicly. However, data from the consultation has been shared with HMRC to support the work requested by the committee in relation to trade. The committee have also requested that HMRC provide trade data for GBDNI movements of chemicals and products containing chemicals, and HMRC have also advised us they will also be addressing that via the UK government EM. So with the updated explanatory memorandum, there will also be updated trade data in there. And at that point, I'll close and I'll pass it back to the chair. I hope we've presented this in a manner that helps the committee in its decision making, and we're very happy to take questions.
Okay, thank you. Just in terms of the cost, you're taking it saying there it could be 88,000 per annum resulting from labelling relevant packaging. So, I mean, that's from the British government. Has the department conducted its own assessment of the costs associated with the regulations here on businesses and consumers? And further to that, I mean, in terms of the methodology used by the HSE, does the department agree with the methodology in terms of the assessment of costs?
Well, the department hasn't carried out any work itself. As I said earlier, we receive expert scientific and technical advice from the Health and Safety Executive of Great Britain. They also deliver the majority of our statutory obligations and departmental functions under an agency agreement. So they are the subject matter experts, and it is via them that we get that kind of information. When it comes to that figure, we've asked HSE to review it and to consider that within the explanatory memorandum. We still have some concerns within the department in relation to the methodology that they have applied, and have asked them to be clearer within the explanatory memorandum.
Okay, and similarly to our previous EU ratings, I mean, have you any idea of when this explanatory memorandum updated is likely to be with us?
It's due next week with the minister to be cleared, so depending how long that process takes. So as far as where it's been drafted, but it's up for clearance.
Okay, thank you. Steve?
Thanks very much, Dave. Thanks very much, Dave, for the evidence. Tim, just help me through this. Hazard classes. So the hazard classes that we currently have in the UK are based on the UN Convention, aren't they? But the UK is not going to change its hazard classes unless the UN Convention changes. But the EU is changing its classes, and that is by 2027 they'll have the classes changed. At that stage, does that mean that chemicals or whatever it comes from GB which will be on the UN convention scale, wouldn't be able to be used in Northern Ireland?
No, the two regimes are separate and are currently operating separately. So if someone wishes to access the Northern Ireland market or the EU market, they already have to apply with those separate CLP regulations. So it would be, whenever they're making future applications, it would need to ensure that those hazard classes that the EU are using are covered. So there would be two separate parallel processes. But it wouldn't prevent a GB company from trading as long as they complied with the updated EU revision.
So basically, if a GB company wanted to supply to Northern Ireland, it would have to follow the EU labelling rules and regulations?
Yes.
So as opposed to now, where it just has the UK rules and regulations?
No, it currently has to follow the EU regulations, but obviously they're possibly changeable.
Yeah, well, they're the same at the moment because
Yeah,
there isn't
it's-
divergence, but there will
yep.
be divergence by 27 because I think the explanation from the House of Lords said that basically the UK is not going to move its hazard classes because it wants to achieve consensus with the UN, but
Yeah.
the EU has decided it's advancing ahead or sideways or whatever out with the UN convention.
Yeah, that's correct. So
Just to get this right, Northern Ireland being part of the EU convention would then be at variance to the UK and the UN convention.
yes. The one caveat with that is that the regulation to bring for the 6 hazard classes happened last year.
Yeah.
That's already in the legislation. That's already gone through.
Yeah.
So it won't be changed by the amendments we're discussing today.
Yeah.
Just to make that clear. But you are correct in your analysis.
So the divergence will be the sort of the key, but we're not talking years away. We're talking the next 2 years.
Yeah. There's different. It depends if it's a substance or a mixture. There's different derogations in it, but it's from 2026 onwards, depending on the circumstance. Yeah.
Thanks very much, Dave.
Okay, is anybody else? David, sorry.
Thanks, Chair. Can I just ask Aaron, in terms of the Department of Health, the Department of Health is going to have sort of oversight in some of these issues. To be honest, I think the assessment of impact from the Department has been relatively scarce and detailed so far. Would you like to give an overview just in terms of the impact that you feel that will have on the Department's work and your stakeholders?
The Department of Health responsibilities in relation to the CLP are relatively minor. So we have surveillance and enforcement and monitoring responsibilities from registered premises, which can be read as pharmacy premises. Generally, the sales from such premises of chemicals and poisons would tend to be lesser, tend to be household goods. That being said, there is the potential that pharmacies can also order chemicals to manufacture medicines, although again, that tends to happen less frequently now as specialist manufacturers will undertake that activity. The impacts there would be, or the role of the department in that sense is quite small, and the changes of the CLP that this amendment is introducing would likely impact higher up the chain at manufacturer and wholesale level before it would reach, I suppose, end suppliers at pharmacy levels.
Thank you. Turning then to just in terms of Department of Economy, just following on probably from the chair's question around costs, and I've got a list here actually of costs that I probably do have and will continue to have concerns around. Less question about that, but you'd said that you had the department hadn't done any work, and I guess it's going back to this area of what's within remits and what's not. But as Department for the Economy, who has the important relationships within the Northern Ireland economy for these things, do you not think it would be worth the department looking at doing some work about what the impact of this may be in terms of costs to Northern Ireland businesses?
Yes,
particularly if you're not happy with the methodology others have used.
As we discussed at the, sorry, let's see the methodology. Yes, and as we discussed at the previous meeting, we'd made an effort to contact Northern Ireland business. So we had, now that was an effort to quite focused target engagement. It wasn't a public consultation or anything at that level. But we identified a key number of businesses within this sector via Invest NI and trade bodies, and wrote out to them to ask them for their input. And that's where we were trying to drill down on not just the cost of them, if there were any other impacts or compliance impacts or supply chain impacts that we needed to be aware of, but the engagement on that we just didn't have, unfortunately. So we haven't got any information back to be able to explore that with business in time.
And this is probably slightly more general point actually rather than specific to this issue, because it's a theme actually sometimes that people, business is not coming back necessarily. Do you think that's an ongoing issue for? I mean, I have no idea necessarily if the scope in terms of different sizes of businesses that you'd have been approaching, but I have concerns sometimes that Northern Ireland being so dominated by SMEs, they're not going to have the relevant staff all the time to provide public affairs analysis and feedback in that regard. Do you feel that the fact that you're not necessarily getting a response is not necessarily a reflection that there won't be an impact?
Yes, we agree that there's a risk in it. We prefer to have engagement, and that's why we're currently in the middle of, with other departments, scoping the formation of a kind of chemical stakeholder forum. That's a provisional title. Chemicals cuts across a range of departments, so we're looking at how we bring that together, terms of reference, and then go out to try and get a range from big manufacturers right down to single person outfits, maybe dealing in scented candles or something along those lines. So that is an aim, and it was exposed whenever we tried to get information at short notice in this instance, that we would, for future instances, we would benefit from having something in place we can consult with very quickly.
Yeah, absolutely, and I think it's work actually as an executive we need to look at in terms of how we support our small businesses on to make sure that where there is risks to them from this kind of the regulations coming forward for the EU, that they are able to be more proactive, because once you go beyond this process, they find out down the line in a number of years there's an issue. It's hard to backpedal in that regard, but that's a more general point. But thank you very much. Thank you.
Jonathan?
Thank you. I agree largely with what David has said there, particularly around the alarm surrounding stakeholder engagement. And I don't put that at the door of anybody that's before the committee today, because evidently you can only really go out to ask. It's up to business whether they contribute or not, but it's probably the type of platform that's difficult. On that particular point, so a fuel industry rep did respond saying that they still had to analyse the impact of changes in labelling at pumps at filling stations. What's the department's take on that potential?
Do you want to take that?
Yeah, it's one bit that the guidance been given so far doesn't cover in detail. Now, fuel is one of the things they deem will be easier under CLP. There's derogations for bulk products sold, and that includes fuel. So we don't expect the fuel to be a massive issue. When it says refill stations, that's actually looking at walking into a supermarket with an empty canister from your home and buying like detergent or washing up liquid. That's what the refill station covers. That isn't petrol pumps, and that's something that would give us a bit of confusion at the start too. So there's more work needs done on that. The one bit the UK government are looking at is looking at the fuel changes in the amendments. That is something they're reviewing. So we'll hopefully know more about that soon. But I don't anticipate the changes to fuel causing any massive issue at fuel pumps.
Okay, thank you.
Okay, just one last question. I mean, is there any information or any more information in terms of engagement about this particular regulation through the Windsor framework structures, between the British government and the EU through the structures of the Windsor framework?
Well, there hasn't been for a while. It would have been discussed at the Joint Committee Working Group, Structured Group for Manufactured Goods, which is where the EU and the UK have those kind of operational level exchanges on stuff that is progressing. But those conversations took place, I think the last time was probably 9 months ago, maybe a year.
Okay, thank you. Okay, so nobody else has indicated that they want to speak, so can I just thank Mark, Gareth, Jonathan and Aaron for coming before us today and presenting that evidence to us. Thank you very much. So, members, just moving on then, under paragraph 8.1 of Schedule 6B to the 1998 Act, the committee must decide today whether or not to hold an inquiry into the Replacement EU Act that has been notified. And so should the committee decide failure will be treated, should the committee fail to decide, that failure will be treated as a decision not to hold an inquiry. So, having regard to the legal advice on whether it appears likely that the Replacement EU Act significantly differs in whole or in part from the content or scope of the EU instruments which it amends or replaces, and the departmental assessments on whether it appears likely that the Replacement Act will have a significant impact specific to everyday life of communities here in a way that's liable to persist, can I ask, do members wish to hold an inquiry into Regulation EU 2024/2865 on classification, labelling and packaging of substances and mixtures? Declan?
Thanks, Philip. And while it's not a direct parallel, clearly these are different issues. But based upon the decision that we made on the last, I think it is proportionate and appropriate in this case to proceed with an inquiry.
Okay, any alternative views? Okay, so committee will have an inquiry then. So I refer members as before to the inquiry timeline, and that's at page 362. And can members agree the inquiry timeline, which includes scheduling oral evidence session from departmental officials on 5th of December and agreeing the final report on the 19th of December. Also, can I seek agreement that the views on this act from the key representatives of business and civil society, which are pages 363, we asked them and get a closing date of 8th of December for them to come back with their views and to include the additional stakeholders identified by Fuels UK. And also just to advise members that as part of the inquiry timeline, a citizen space survey will be promoted on social media platforms and that anyone will be able to respond. And as with the previous thing, you know, the general point about EMs, we need to notify, and also that we make the particular point that this in our inquiry timeline, and we really need to see the EM as part of the inquiry timeline. So are members content with all of that?
If I could just come in there, if members are content that a copy of the Fuels UK response is also forwarded to the UK government asking for comment.
Okay, grand job. So next item then is operating procedures for the standing order on substitute members that went through the Assembly this week. Can I just inform members that the relevant papers for this item are pages 3 and 4 of the meeting pack, and a letter from the Committee of Procedures is at page 36 of table papers. Just to remind everybody, standing order 59A was agreed by the Assembly on Tuesday and came into effect immediately. This provides for the establishment for this committee as a standing committee of the Assembly and allows for members of the committee to avail of substitute members when necessary. There will be a formal review of the arrangements in the autumn of next year, but we will continually review their operation and will endeavour to address any issues if and when they arise. I'm going to ask Sinead to speak to this item.
If we can refer members to page 3, the table at page 385 of your packs. So you'll see in the left-hand columns are the relevant section of the standing order, and then in the right-hand column are the proposed operational procedures for this committee to agree. So it's essentially our own practical rules in terms of how substitute members will operate. So I'll just run through them. A member must inform the committee in writing by email if they wish to nominate a substitute member from the same political party at least 4 working days prior to the committee meeting at which the substitute will attend. So that is the Friday before any committee meeting would take place. And that's just to ensure that the substitute can receive all of the papers on the following Monday. The substitute member should be copied into the email. Where a member gives notice of a substitute member to the chairperson verbally during a committee meeting, this must be followed up in writing by email. The member must specify the full name of the substitute and the date or dates at which the substitute member will attend. A member can only nominate one substitute at any given time. A substitute member can be in place for one or more committee meetings, provided that the relevant dates have been specified in the email. However, members should avoid appointing substitutes on a long-term basis. Only a permanent member of the committee can nominate a substitute member. So, for example, members of the same political party can't nominate a substitute for each other, nor can a substitute nominate another substitute member. A member should use the same substitute where possible for the purposes of continuity. This provision will apply at any time when the DSC meets. However, its use out of recess period should be only in exceptional circumstances. A substitute may only attend a meeting if the committee office has been informed according to these requirements. Only the named substitute nominating in writing may attend when the permanent member is absent, and the permanent member must be absent for the whole of the committee meeting for a substitute to be in place. The substitute can carry out all functions of the member, including taking part in a vote. No substitute member can take on the powers and duties of a chairperson, and therefore no committee meeting can take place or continue unless at least one member present is a permanent member who can chair the meeting.
Okay.
So those are the proposed operational procedures to be agreed by the committee, and if there were any subsequent changes, any changes to that would have to be agreed in committee also.
Okay, Sinead, thank you very much for that piece of work. So,
Sure.
Yep, go ahead, Jonathan.
Yeah, it's just a point of clarity, Sinead can maybe explain. So obviously it states, that it must be received in email at least 4 working days prior to the committee meeting, and understand the reasons for that. Then it goes on down further where a member gives notice of substitute members to the chairperson verbally during a committee. Is that before the 4 working days, or is that after that?
That could be at any stage, but it's just to make it clear that if it happened during a committee meeting, that it'd have to be followed up in writing, that notifying during a committee meeting wouldn't suffice, there would have to be that follow-up by email.
Because I'm thinking when you go on to the next point further down, which talks about, it should be used in exceptional circumstances, e.g. illness or family circumstances.
Yeah.
Well, the 4-day, an illness could happen a member a day before, and I'm just trying to wonder how that factors in, or something could crop up with their family. I'm not sure. I'm just trying to work out how we're taking in that. Maybe you've included that, and it's just how I'm interpreting it.
If I could just come in there, the rules are for normal working circumstances, but you would know the Thursday or Friday before that you want to have the substitute. In circumstances where there was 1 day before, I suppose if the committee wanted to agree that in those circumstances that's acceptable.
I on that basis, that was going to be the question I was going to raise as well, and I would be more in favour of shortening that and encouraging that people should notify in 4 days. But there'd be many of us here, I would imagine, well, certainly I don't mind admitting to the fact that who will be reading our papers, the day before or whatever, and going through them and all that, and depending on the week that you have. I think particularly if it's in exceptional circumstances where you have an illness or a family situation, I think it's important that people are able to nominate their substitute with a shorter period than 4 days. So I'd agree with what I think Johnny's saying on that.
It's just, exceptional circumstances, which the provision is really for. Illness and family circumstances, I don't think we can put a time frame in that.
Yeah.
That's just my concern.
Sure, it could be changed to normally, I suppose. Yes. There are a number of people have indicated here.
Yep, I can see, Joanne. I just want to come in on that point because I think as a committee, we need to be very careful. We have got this standing order agreed by the Assembly because of the special nature of this committee and the fact that it meets during recess period. So I think we need to be very careful. So, I could be ill today, but I don't see that as a special set of circumstances specific to this committee because I could miss my other economy committee. So I think that, and we did suggest this, that, we might allow for a wee bit of legroom, but primarily we should be keeping this in my view, to periods of recess only. So, no, if I get the flu today, I mean, I don't see that as the circumstances where I would have a substitute member. If because my holidays are over recess, then I think that does apply. So I just think we need to be very careful when we use this. And I would like, as the chair of the committee, to see it primarily being used for recess periods only, to avoid a scenario where members can't do other things, but that this committee can also do its business.
I would agree with the chair.
Ron?
Thanks, Chairman. I understand what you're saying, and I understand the reasons behind the standing order. I suppose just coming on the back of David and Jonathan's point, part of the issue too is though that the Assembly was moving towards what was supposed to be more kind of family-friendly working. A number of members of the committee have young children, and certainly whilst I don't have young children, I'm a carer for my elderly mother. So sometimes difficult circumstances arise. And that's not, around any unwillingness to be at the committee, but sometimes, emergencies befall us all. So I understand what you're saying, but maybe we can strike a balance in there somewhere, because the Assembly indicated it was going to move to more family-friendly policies and so on. But thus far, there actually aren't any signs of it.
Okay. Declan?
Yeah. And up on the last point, I don't think that we should mix our apples and our oranges together. There is a separate process around ensuring that the Assembly as an institution functions to the greatest extent possible in a family-friendly way. But by the same token, there are rules of procedure governing the work of this committee. And the danger is that if we start to pull the thread of the Gansey, then eventually you get to the point where there's really nothing left. So we do need to approach this, I think, with due regard to the fact that governing procedures exist, that they need to have primacy, that yes, of course, we always need to allow for the exceptional circumstance, but I think it would be a mistake to start to muddle our approach towards conforming with the operating procedures, the rules of the committee, and then really entering in undefined caveats. So I think the balance, the landing zone here is that it would be in very exceptional circumstances, Marie. So Philip makes the point around recess, makes the point around somebody coming down with an illness at short notice. I think that we could enter in the idea or the caveat of exceptional circumstances, and in those exceptional circumstances, that being referred to the chair and the deputy chair of the committee, and that discretion is left with the chair and the deputy chair of the committee to adjudicate on that exceptional circumstance, rather than us trying to create a whole set of qualifications to the existing rules. If we do that, I think we open the door to confusion and a whole lot of difficult precedents being created that could in fact down the road conflict with the operating procedure of the committee. So I'm advising that we go for exceptional circumstances, but that exceptional circumstances are then referred to the chair and the deputy chair for an adjudication at that stage, rather than us trying to rewrite or amend the procedures that currently exist.
Owen and then Jonathan.
Okay.
Yeah, thank you, Chair. And look, broadly content with the approach that Declan has suggested. I mean, I'm open as to whether that's a decision for the chair and deputy chair, comfortable with that, or a decision for the committee. I don't mind either way. But I think it is important that we don't do the work of the Procedures Committee here. So it's for the Procedures Committee to consider wider issues around flexibility and approach to illness and so on in terms of committee attendance. You're right, Chair, when you said that this was a specific request that we made in terms of the fact that we have to sit over recess periods. And it's very possible that a committee be called whenever someone is out of the country or off on leave with their family or whatever it might be. In those circumstances, people will know in advance that there is a requirement for a substitute member, and so I think the proposed operational procedures here are reasonable in that circumstance. I don't discount the fact that there will be, as Declan has outlined, exceptional circumstances which we can't foresee, and I think rather than us trying to sit here and foresee every possible issue that might arise, having that flexibility is a sensible approach.
Okay, Jonathan?
Yeah, no, look, I only brought it up because I thought it was a point of contradiction in terms of illness and the 4 day. I don't want to be prescriptive on this either, and we can't really, as Owen says, predict some of the circumstances that might happen in the future. So I'm largely comfortable with what Declan has said.
Yeah.
I suppose the only thought that I had on that was, do we need to change that at least 4 working days part? That's the only bit that I would say that maybe would contradict that, but I totally agree. It should only be used in exceptional circumstances. That's absolutely right. And if there's a formal process by doing that through, bringing to the attention of the chair and deputy chair, I think largely the committee will find themselves in agreement, because exceptional circumstances do come up. I'm just wondering whether or not we need to reflect that in that particular wording.
Okay, I'm going to ask Sinead just to come back in.
So, if based on the discussion, if I could just propose a change to the first bullet point under subsection 6. So, if we qualify that to say that at least 4 working days prior to the committee meeting at which the substitute will attend, unless in exceptional circumstances to be agreed by the chair and deputy chair.
Happy with that.
Agreed. Yeah.
I think that's a perfect compromise.
Yeah.
Okay, everybody content with that? So on the basis of that amendment, can I just ask then, are members content to approve the operating procedures as outlined by Sinead, on the understanding they will be subject to continual review?
Agreed.
Okay, thank you. So correspondence then, next item. So at pages 389 to 392, British Government has shared an updated EM on Directive EU 2024-2839 concerning certain reporting requirements in the fields of food and food ingredients, outdoor noise, patients' rights, and radio equipment. So the regulation is not subject to a committee inquiry. Are members content that the updated EM is published on the committee's webpage?
Great.
Thank you. Page 393, the British Government has shared an updated EM on regulation EU 2024-2838 concerning certain reporting requirements. Regulation again is not subject to a committee inquiry. Are we content that the updated EM is published on our web pages?
Agreed.
Okay, thank you. Chair's business, I have none. Any other business? Steve, you had indicated you wanted to raise it.
Yes, Chair, and just through the committee. I make a declaration of interest I made in closed session earlier on that I've been contacted by many of my constituents and indeed by many businesses across Northern Ireland on EU regulation 2023/988, which we all understand is GPSR. And that declaration is that I've been asked whether this committee would be willing to take an investigation under paragraph 8.2 Schedule 6B on the Northern Ireland Act on this legislation, in that the GPSR regulations are a significant change. And if we look at paragraph 8.2b of Schedule 6b, and it says when reaching a decision, the committee must have regard to whether it appears that the replacement EU Act would have a significant impact specific to everyday life and communities in Northern Ireland in a way that it's liable to persist, and may have regard to other matters the committee considers appropriate. Now, I know we may not consider this as within scope of what we would normally do. However, I think with the considerable public interest there is on what is now a divergence in trade and has been seen to be a divergence in trade, I would ask the committee whether it will consider conducting an inquiry on EU 2023/988 GPSR.
Okay, just before I allow anybody else to come in and people want to indicate, do so. But I mean, legislation that set up our committee gives us a very specific statutory task, and it's in relation to developing EU laws. It develops so the mechanisms in the regulation, that is storm and break applicability motions, only apply or they only apply to disapply future EU law. So in effect, the mechanisms are forward-looking, not backward-looking, and that's the context in which this committee operates and has been operating. So we've discussed this before. The examination of consideration of proposed new EU acts and proposed and published replacement EU acts rests with this committee, whereas this issue, which has long since passed, is an implementation issue post-legislation, and that rests with relevant statutory committees. So statutory committees will want to continue to consider EU exit-related issues that fall within the functions of their department, might include engagement or policy development, and the scrutiny and implementation of EU acts. So, I've received correspondence in relation to this issue, as I assume all other MLAs have. I'm not saying it's not an issue. From my point of view as the chair, I believe it's an implementation issue, which is an issue for one of the other statutory committees and not this committee, but I'm happy to explore other views that members may have. I don't know if anybody else has indicated. Jonathan?
Thank you, Chair. No, I would share Steve's concern in relation to this specific EU rule, particularly, obviously, as MLAs, we've been lobbied on this by constituents, yes, but also the fact that it has entered also into the media space in terms of its impact on GB to NI trade and ultimately which will impact upon the consumer. So share the same concerns, and I would be happy to second his proposal that we conduct an inquiry into the impact of this particular regulation.
Owen?
Chair, I was just going to ask through you whether the clerk, and I appreciate it's AOB, so it may not be in a position to, but can advise on whether this is actually within the virus of this committee.
Well, as the chair has set out, the remit of this committee is the examination consideration of proposed new acts and proposed and published replacement EU acts. The statutory committees still have a responsibility to look at the outworkings of EU exit. And they would obviously have the powers and functions to be able to conduct an inquiry if they so wished. But this committee's powers lie with its very strictly defined functions.
No, thank you for that, Sharon. Just with your indulgence, first of all, I think it's important that we point out that the reason why we weren't in a position to conduct an inquiry into this matter at an earlier stage is because the Assembly at that stage was being held to ransom, and so this committee wasn't functioning. So I think that's the first thing to put on record. But secondly, in terms of finding a way forward, I think it would be in order for us to write to the Committee for the Economy and bringing to their attention the concerns that we've heard as a committee, and allowing the Committee for the Economy as the relevant statutory committee to consider whether any further action is required. But I think there's a wider point, Chair, in that I think a number of members on this committee risk bringing the committee into disrepute by regularly misrepresenting what this committee was established to do and what its terms of reference are. And I would also say, Chair, that if people have a problem with the procedures of this committee, they need to speak to those members who negotiated into existence, rather than casting aspersions on those of us who come to this committee regularly and faithfully implement the legislative provisions and the procedures set out. So I think this committee, if we continue to go down this line where members continually try to point score and to misrepresent our purpose here, risks bringing this committee further into disrepute. I think we have done a rather good job, actually, Chair, over the past 8 or 9 months, conducting business diligently, conducting inquiries where that is proportionate, and ensuring that we're always acting in the best interest of people in Northern Ireland, businesses and consumers. And I hope that that can continue, and that this doesn't further deteriorate in the time ahead. Thank you.
Okay. And speaking as the chair, I'm slightly biased. I'm going to agree with you. I think the chair or the committee has done a very good job in a very serious matter, that we're dealing with. I think we all take the issues before us as such seriously, and I do believe that the committee has a difficult task, but we have a very specific role and remit, and to this point I think we have done just that, and I do agree with you that there's a danger of us stepping outside that. So, there's a proposal for Steve, from Steve.
Chair, can I just come back in and maybe a sort of a piece of guidance I think we probably need, because because the EU legislation doesn't actually come into force until the 13th of December. So actually it's still extant. It hasn't actually been given legal effect yet.
Well,
so the question...
We don't need that, Steve. Sorry to cut across you. There's a proposal and a second. I'm just going to take a vote on it and then we're going to move forward. So Steve has made a proposal that the committee take an inquiry. So, can I ask those in favour to raise their hand? Okay, those against?
Okay, so the question was to conduct an inquiry into the implications of Regulation EU 2023/9888 on general product safety. Ayes, Jonathan Buckley, Joanne Bunting, Steve Aiken. Noes, Philip McGuigan, Declan Kearney, Emma Sheeran, Owen Tennyson. So the proposal falls.
Okay, thank you. Just then on Owen's proposal, are the committee happy that we refer this issue that was raised to the Department for the Economy?
Intent.
The Economy Committee or the Department for Economy? Economy Committee.
Oh, sorry. Yeah.
The committee chair, but would be happy if correspondence went to both. No issue if
to the permanent secretary as well as to the committee chair.
Yeah.
And probably to the TEO again through the chair.
Okay, thank you. Yep, happy with that. Okay, folks, so that's any other business dealt with. So if I can just get to my appropriate place. So the next item and last item on the agenda is the date and time of next meeting. So next meeting is going to be Thursday, 5th of December at 10 AM in room 30. So thank you very much for your attendance. Okay.
Committee Room 30, sound.